Mr. Brown, you may proceed.
Thank you, Your Honor. I looked up and there was an empty chair, so thank you. May it please the court, my name is David Brown. I'm representing Zane Blessum in this ethics appeal. You had an opportunity to read the briefs, appendix, realize that at the hearing below, it was recommended by the grievance committee that he be suspended for 4 years. We appeal from that ruling. Let me start in this way. The way I've read a number of your opinions over the last several years is clearly it's de novo review in this court. And secondly, even credibility findings can be made in an ethics case. I've learned that painfully a couple times, but I also know there's a reason for that rule. And this case is the reason for that rule. A lot of issues came up in terms of Mr. Blessum's representation of Jane Doe in a divorce case. Understood, factual. To get into this case as a grievance proceeding, it was not fair. An attempt was made to bring in Tim Pearson, a very well-known lawyer in this community, an expert clearly in any category, you'd say criminal, not criminal law, domestic relations law. Very, very knowledgeable in that area. He had a letter, an opinion, relative to the delay in entry a quadro in this case, which was what was alleged was the neglect. Yes?
Mr. Brown, let me try and, on the Pearson issue, even if that was total error, that only goes to the neglect question,
true.
Right?
Absolutely.
And would you maybe agree with me that kind of putting the different pieces together, the neglect is a fairly minor part of this case, that the domestic violence, domestic abuse situation, and the sexual relations with a client, and those are the more serious issues, or am I misreading it?
No, you and I are on the same page. But what I'm saying is it set the stage. That's just one point. Mark McCormick had a letter that related to the assault issues and the criminal plea and how that may or may not apply in an ethics world. That opinion wasn't permitted either.
I read the McCormick letter. It struck me as mostly legal analysis. Correct me if that's not correct.
I didn't read it that way. What I read it was he was attempting to explain to the trier of fact in a grievance proceeding how matters that are happening in the criminal world may or may not apply in the world of ethics. And he had a lot of experience, obviously, in ethics cases. I think it would be helpful to them. I don't think it's the ultimate fact. I don't think it's in violation of Grismore. But that's a second issue. But this is a warm-up. You're right. I would say the neglect issue and the Pearson letter are just a small part of it. But then you get into the case itself. And the nice thing is that on the case itself, you do get an opportunity here to read the appendix. And I assume the transcript went up as well. And I did have the opportunity, a bit of a nightmare, to reread that as recently as this morning again. I've never been in an ethics situation where there is key evidence that's attempted to be elicited by one of the counsel, representing a licensee who may lose his or her license for whatever conduct, where there's an objection, relevancy, sustain, relevancy, sustain. There were 10 of those. There was no ability to give context to what occurred.
Did you make an offer of proof on those matters?
There were offers of proof made on a couple of them.
So if we decide the rulings are wrong, we can review them just like we can review the letters if the letter should have been admitted.
That's right. Justice Wiggins, there was, I think, a couple of offers made, and there were not offers made on every single time that an objection was sustained.
Well, whose problem is that if they fail to make the offer of proof?
Well, I think the problem is the context of what that hearing was like. In terms of basically preventing evidence from coming in, the prosecutor objecting, the head of the panel sustaining the objections, you can feel the climate and you read that transcript. So let me go furthermore. There were some offers made, and you read those in the transcript. What was the impact of those offers being made? Well, you read the opinion. Of course, I didn't bring that up here, but the opinion of the grievance commission. Blessum gets punished for making any attempt to defend himself.
Well, I can assure you we'll read the transcript.
Oh, I know you will.
With care. So it is de novo review, and with my assurance, and I know my colleagues, I mean, we will see what the evidence was offered, and we will do our de novo review. So why don't you address what the record shows?
I will, and thank you. But I did want you to start with that proposition, because I think it's rare to make a credibility finding contrary to the grievance committee on appeal, but it does happen. And there is a reason for the de novo review, and that's this case. So let's start with neglect. The easiest one, as Justice Mansfield illuminated earlier.
I really, from my perspective, you're the lawyer, you can focus on what you want. I'm more interested in hearing about the sexual relations with the client, and then the domestic abuse, criminal conduct adversely reflecting on his fitness to practice law, because those really drive the severe sanction in this case, as I see it, not the neglect.
Right.
But that's just me, and that's my
No,
suggestion.
I'm just reading the time, and I'm not disagreeing with you as I think of the tea leaves. But we agree on one thing: the neglect is the minimal part. Now, the sexual relationship. The reason that I think there's some chronology you need, and I don't know that came out completely in the briefs. I wasn't there as trial counsel, Mr. Gummert was. But when you basically look at it, the representation started in 08. The decrees entered in 09. There's no contact between the attorney and the then client at the end of 09. And I think one letter in 010, and then she comes in the early part of 011, and they get to...
But I'm going to disagree with you a little bit. During this entire course, pursuant to the stipulated decree that they entered in this matter, there was still an ongoing legal obligation by your client to process in a timely or untimely fashion. You know, we can dispute about that. You know, the qualified domestic relations order in this matter. And so I guess I'm just telling you, I take the view that during this entire course, until he finished his representation and finished what he was obligated to do under the terms of the decree, and I think under the terms of his representation of this person, he's still representing this person.
And I'm not suggesting that I disagree with you. I'm just basically in terms of what was their interaction. Yes, he was still counsel of record, and yes, he hadn't gotten the quadro entered. In terms of was there any interaction between them as a client in your office and seeing her, and the answer I think is stipulated by the evidence, no. Now, is there any way to justify a relationship with a client even under this extended set of facts? None. And actually, when Blessum's under oath, he doesn't try to defend it in the least. Actually, the suggestion in the ruling, and I think I'm okay time-wise right now, that he wasn't contrite is simply not the way I read the transcript. He understands he blew a 30-year marriage. He understands he's put his entire profession at risk. He understands, and he indicated under oath, he'd never varied from his wedding vows before, understands this is just unacceptable behavior, and he takes full responsibility for it.
Let me, because I have looked at the transcript, let me tell you what I see in the transcript, and then tell me if I'm wrong. What I read, what I understand is there's this situation in early 11, as you point out, where Jane Doe comes to Mr. Blessum and says, I'd like you to prepare a will for me. And then they get affectionate that evening, but there's no sexual relationship. They continue socializing, and then a sexual relationship develops a couple of weeks later. Is that am I reflecting the record accurately so far?
That's my best read of it.
All right. And why isn't, at that point, once she comes to him and says, I'd like you to do a will for me, why isn't she a client apart from the quadro and the issue about whether...
I agree with you. Clearly, she was a client. I'm not justifying a single thing that he did in terms of
But as I read the hearing, he was denying that she was a client at the time the relationship initiated.
Well, that's not how I read the entire transcript. I think in the opinion of the grievance committee, they're saying, well, he's contrite, but he's attempting to defend himself. Well, okay, he's attempting to give context to it. But in terms of, was he denying that he was her lawyer, I didn't read the transcript that way, Justice Mansfield. I really didn't. Now, if I could move quickly, we didn't get to the assault. Could I have a moment?
Why don't you take a minute or two and just talk about the assault?
I will. Thank you.
Compare it to Schmidt, please.
I will. I'll do that. As I see Schmidt, which I think ultimately was for this court, 911 call, police out. I think the woman is almost close to being strangled. He is arrested. He is in a car. He does kind of do some things in the police car. Ultimately, he pleads guilty. There's a domestic relations case. It's pretty volatile with his now ex-wife. And it went up, and I think ultimately the sanction there was 30 days, I believe. In this case, again, by comparison, frankly, I think Schmidt factually was far more egregious than anything that ever happened in Blessum. What happened in Blessum is factually is, quote, former girlfriend goes to, quote, his house. She blocks his driveway. There's a question as to the pills, whether she's trying to harm herself or not, although she had to acknowledge one pill would be right, 5 pills is probably too much. I mean, who knows what would have happened if she'd have taken them. There's no question she goes in and assaults him. No question whatsoever. There's not defending the fact that he kind of overdid it. No question about that either. The 911 tape is...
Have you listened to the 911 recording?
Absolutely.
And I have too, and it's
hideous.
not very good evidence for your client. Would you agree?
Hideous. Hideous. And I think that kind of parallels, frankly, what I think happened in Schmidt. Very much so. But in terms of overall, where he's attempting to help her car was towed, he helped her back with it. Basically, he did plead guilty. He took responsibility for what happened. He was incarcerated. He paid a fine. He went to anger management. He's gone to counseling since, his pastor and a psychologist. And he realizes there's no excuse in the world for what happened. And yet you look at the opinions, and again, just a couple seconds here, they're all over the map in terms of what is the sanction that should be imposed in light of this kind of conduct. And our belief is the 4-year suspension is unwarranted, it's excessive, it's punitive. Obviously, we're not ignoring the sexual relationship, we're not ignoring the fact there was an assault and he pled guilty. But 4 years is simply too much. Thank you very much.
Thank you, Mr. Brown. Ms. Quinlan?
May it please the court. I'd just like to roadmap what I'm going to talk about today, and that is I would like to first talk about the violation of 32.8.4b, which is professional misconduct for a lawyer to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness in other respects. The two cases, and then I'll talk about sanction. The two cases with respect to Rule 32.8.4 sub b are the Templeton and the Schmidt cases, both of which the court actually held in the end that 32.8.4b was in fact violated. Templeton was the Peeping Tom case. The focus became whether the court said the focus was on the link between the conduct and the actor's ability to function as a lawyer, and that there had to be some rational connection between the criminal act and the lawyer's fitness to practice law. Templeton and Schmidt cases outlined 5 factors that the court considers when assessing whether there's been an 8.4b violation. First, it's the lawyer's mental state. The second is the extent to which the act demonstrates disrespect for the law or law enforcement. The presence or absence of a victim, the extent of actual potential injury to a victim, and the presence or absence of a pattern of criminal conduct. The only one of those factors that was missing in this case was the presence or the presence of a pattern of criminal conduct. That was also missing in the Schmidt case, but the court still held that 32.8.4b was.
Ms. Quinlan, I again, just speaking for me, I don't have trouble with the proposition that that rule was violated, and it almost sounds like Mr. Brown doesn't either. I'm interested in how do we get from the 30 days that was imposed in Schmidt to the 4 years that the commission recommended here? Well,
I think that part of it is you do walk through some of the connection between his fitness that also goes into sanction, and I would say that regarding his fitness, that he knew during the assault, he stated things to the victim, Jane Doe, that he knew as a result of the attorney-client confidentiality between the two of them. He also, after the assault, they got back together again, regardless of who got back together with whoever first. They got back together again, and she believed, and she testified at trial, that she believed that, in hindsight, the reason he got back together with her was because he wanted to manipulate her not being able to, or coach her, I should say, on not filing charges in Dallas County against him. And he had specific knowledge of how to do that, told her who to call, who to contact, what to do in order to not have those charges filed against him. So I'm just going to go right over to sanction, I guess, and talk about there is no case on point where there's an intersection between an assault and a client or a former client, and where there's sexual misconduct involved. To the extent that there's the nature and the extent of the ethical violations, we have neglect, intimate relationship with a client, criminal misconduct, and trust account violations. And clearly I agree, it's the intimate relationship and the criminal conduct that are really the most serious in this case. The board doesn't believe
Counsel, would you agree that if you focus just on the domestic abuse incident that night, which is worse, what Schmidt did or what Blessum did?
I think what is different about the Blessum case is that she was a former client, and that he had certain information and had obtained certain confidentiality, and there was a trust relationship brought about by the attorney-client relationship that he played off of during the assault and then afterwards. And I think that that makes it more egregious in this case, that he had those confidences and used them against her during the assault and then afterwards to try to manipulate her not to file charges.
And how does this case line up with Ruth, where he got a 6-month suspension for included domestic violence, but also an OWI third for him?
There was not a client involved in that case. Okay. Again, I think that's really the key here. The aggravating, I guess that one of the things I would have the court look at is in terms of what case do you look to in terms of sanction. And I think that the McGrath case has aggravating circumstances, and it also has mitigating circumstances. They're at least somewhat similar to the instant case. The mitigating circumstances in this case were that the assault was out of character. It was an aberration, kind of like in the Schmidt case. The conduct did not affect his behavior towards his clients, his fellow lawyers or judges. That certainly was held in Schmidt, although I think that really had more to do with it was conduct not prejudicial to the administration of justice, an 8.4D violation, which was not found in Schmidt. Schmidt took responsibility and was remorseful. He sought treatment at the beginning of the criminal prosecution, and we don't have that here. The aggravating circumstances in this case were our lack of remorse, trying to shift the blame during the hearing back onto the victim, using her behavior as mitigating for what he did during the assault, and even mitigating his getting involved with her sexually, that she somehow came on to him. He's failed to admit the wrongfulness of his conduct and only admits to the trust account violation. His experience, he's practiced law for almost 30 years now. That is an aggravating circumstance. And of course, the multiple violations, which in the commission's view, it held that having all of those violations involving one client was aggravating. The McGrath case, as I said, that there were aggravating circumstances in that case, but I think most of the one aggravating circumstance in that case had to do with sort of that creep factor that involved his exchanging sex for fees with one client and then propositioning another one. He had no prior misconduct. He was well respected in the legal community. But what the court went back to was to emphasize the client's vulnerability, which we have here, the victim Jane Doe in this case. Again, respondent used the confidences that she told him during the attorney-client relationship against her during the assault, information that he was supposed to use to protect her, not use against her. I think in terms of the factors involved in a sanction, I think that the court should reevaluate physical violence cases, and if that's what the court wants to look at in terms of a client's, the vulnerability of anybody in a situation where there's violence. But I think where it plays into, particularly in this case, is that the court has an obligation certainly to protect the public and certainly to maintain the reputation of the bar in cases involving violence. And I think that distinguishing this case in terms of recognizing that Mr. Blessum used confidential information against the victim and also tried to manipulate her in terms of what he told her to do, who to call, and what to do in terms of not getting charges filed against him, that those are two very important aggravating.
Do you think 4 years is an adequate sanction? Or
do I think 4 years is?
Too harsh, too lean?
There's no precedent for it. The McGrath case is 3 years, and it's a different kind of aggravating circumstance, but if the court is going to balance mitigating and aggravating circumstances, there certainly is language in McGrath to allow that to happen and have it be. I think that the 3-year range is about right in this case.
That'd be based on a comparison to McGrath?
Yes, somewhat. I think that case has a lot of the features in terms of aggravating circumstances. I think that the assault would replace the sex for fees aggravating circumstance in terms of being an aggravating, adding to that. But it's also a separate violation as well. So under 8.4 sub B, I can see that my time is almost up. Yeah, sure. The board respectfully requests this court to find that each of the rules alleged in the complaint were violated and ask the court to impose the sanction along the lines of the 3-year suspension imposed in the McGrath case. Thank you.
Thank you, Ms. Quinlan. Mr. Brown, do you have any rebuttal?
Thank you. In response to these questions about Schmidt, if you read the facts in Schmidt, I think the underlying facts are much more egregious than anything that happened here. I mean, the reality is, this is his wife. Who's gonna know more about you, I would think, than a spouse?
This was a client.
Well, this was a wife. He almost killed her. And the fact is, but for the grace of God, that would have been state versus, as opposed to basically a committee versus. It was that close.
Well, Schmidt had some criminal charges against him, and the judge made specific findings about his character. Schmidt also spent 5 weeks in an inpatient treatment place. Schmidt also spent 2 weeks at another inpatient treatment place where he didn't practice law. What has your guy done equivalent to what Schmidt did before he came before the committee? Other than, and what did he do? Did he stop practicing law during that time? Because the evidence in Schmidt was he stopped practicing law during that time.
Sure. I don't know that I have any evidence, or I'm aware of any judge that he quit practicing law for a period of time. I do know, he went to the anger management that was ordered in the domestic abuse. I also know that the record was uncontradicted in the transcript, that he basically was going to a psychologist and I think a pastor to deal with this issue, And I take that seriously. Now, did he go to an inpatient place? I'm not aware that he did. I'm not. So in terms of, yes, it's true, some actions were taken by the defendant, but in terms of the underlying facts, that's what I'm getting at. I mean, I think that was at least part of what the question was going earlier. What's the differences? I think the aggravation was considerably more in the first case. Also, I want to mention McGrath.
Back up a second. And I hate to do this to you, take up your time, but what do you think would be the proper sanction?
Well, I think the proper sanction is someplace between 30 days and 6 months. I think if you take a look at the majority of the cases, and I think the court is attempting to kind of have at least a predictability component. I'm aware of at least one case, which was not a violence case, but a case where you have a federal conviction. We disagreed on that one, I think, Your Honor, but actually 6 months was what happened in Wheeler. I think there was one where somebody had a federal firearms conviction, and I think the case was dismissed. So you never know exactly how that range flies, but I think 30 days to 6 months maximum.
In what way did he misuse client secrets during the assault?
Well, I appreciate you mentioning that, Judge. I'm not aware at all what anybody's talking about. Now, I have listened to the 9/11 tape, and probably, unfortunately, all of you have too. It's hideous. I mean, there's no excuse for it. Nobody can defend it. Is there something that he said that is using information that he knew otherwise? I didn't hear. I heard them yelling at each other. A lot of it I couldn't make out. What I could make out was pretty crude, pretty awful. But in terms of that, I didn't understand. There was some specific information he knew, only he knew because he'd represented her. I didn't. Now, if I could kind of get to McGrath for just a second, I know that case well. That case involved an allegations against Mr. McGrath involving 3 different clients. And I think that was a somewhat a situation in some of the underlying cases that you've had before, where you've got essentially a predator. Essentially, the claim was. I still disagree with that, but that was certainly the finding of this court. 3 different people, 2 that were claimed to have been sex for fees, or at least a wish list, I guess, not effectuated. And then even though the underlying grievance panel found there was no sex between the 3rd person and the attorney, this court made a credibility finding that there was. So you have 3 different instances over a considerable period of time, a pattern of conduct. This is clearly an aberration for Zane Blessum. There isn't anything in his record. I think he did have a private admonition, we don't know for what, some years earlier, but this is so far out of character for anything that he's ever done that it is purely indefensible. He knows it. It cost him his marriage. It cost him his reputation. He's here asking for justice and mercy. But to look at it, that you're obviously looking at all the factors you look at. You're obviously looking at the public interest. You're looking at the profession. But you're also looking at the underlying facts that actually happened. And that's really, I think, probably the most sacred role you have as a court. I have total confidence in looking at that the range that you'll come up with will be much more in line with what your prior cases have been and what the facts of this case justify. 4 years is excessive, it's abusive, it's punitive. I don't think that's the intent of the ethics rules. I don't think that's the intent of the procedure. And I would ask you to take a very careful look at it and adjust it. Thank you very much.
Thank you, Mr. Brown. This case is now submitted, and we'll hear the case of State of Iowa versus Gaskins.